Yaakov Abuhav representing myself.
That's you, sir? Okay, and during the presentation of evidence today, sir, when it's time for you to address the court, I'm going to require that you stand, please. Okay, thank you. And Councilor Bennett?
Good morning, Your Honor. I'm Matthew Becker. I'm the attorney for the town of Grafton, and with me here at the defense table are the three selectmen from the town of Grafton. We've got Lief Huge, H-O-G-U-E. We've got Ed Grinley, G-R-I-N-L-E-Y. We've got Steve Darrow, D-A-R-R-O-W.
Mr. Hogue, Mr. Grinley, and Mr. Darrow going from my left to right, am I correct? Going from your...
Hogue, Grinley in the middle, and Darrow furthest to your right.
Okay, thank you, Attorney Becker. And I did receive word that there was a motion was filed, am I correct, this morning, Mr. Abuhav?
Yep.
And what motion is that? I don't currently have it on the screen.
Basically just a motion to sequester witnesses.
Okay, and what witnesses are you looking to sequester, sir?
The ones filed by the defendant.
Okay. And Attorney Becker, any response to that?
I wasn't aware of the motion, Your Honor. I think the court's deadline for filing pretrial motions was a while ago, and the three potential witnesses that the town has, these are members of the Board of Selectmen. Everything that is at issue in this case occurred at public meetings and was on video at which all three selectmen were present. So there's, even if the motion weren't extremely belated and prejudicial at this point, there would be no grounds to require sentence years.
Okay, Mr. Abuhav, your response?
Their testimony may in public will differ a bit on what happened or some of the details because you have sequestering so they don't studying from each other what to say.
Okay, and specifically who are you looking to sequester?
More.
Okay, the board would be considered a party under the circumstances?
Are they considered a party under the court rules if they're listed as a party? If they are going to fall under the party, then sure.
Okay, so I'm going to deny the request as it relates to the board because they would be considered a party.
The party is an actual person.
What's that?
The party is an actual person.
Because they constitute the board as a party. I'm also going to state for the record that the fact that they happen to be in the courtroom at the same time is something that you can point out relative to any inconsistencies or consistencies relative to their testimony. The other thing I'll point out is that this is a bench trial; it's not a jury trial. So, with respect to the witness's testimony, the court is acting as finder of fact in this matter, and the court will take into consideration the fact that they were in the courtroom as members of the board, as acting as the board on behalf of the town of Grafton. And so the court will take that into consideration as it relates to their testimony, including any cross-examination or comments that you would like to make with respect to their status in that regard. Are there any other non-board witnesses that you requested to be sequestered?
That was all that was listed.
Okay, understood. And I heard, so there's two motions that were filed, am I correct?
No.
Just that one?
Yeah.
Okay. All right, and my understanding is that there have been documents that have loaded in the case lines, am I correct?
That's correct.
Okay. I don't have that permanent on the screen. I don't look at the evidence ahead of time. I'm currently logging on to the case lines application right now. spinning wheel stopped, exhibits are loaded, and for those of you who may not be aware relative to the case lines application, just make a brief comment. The state of New Hampshire, with respect to non-jury trial events, including hearings and bench trials, the state of New Hampshire is attempting to make the presentation of evidence into a non-paper, a paperless function. And although there sometimes are delays, such as what just happened here, it is my experience over time that there may be some delays from time to time, but it's still big picture. It still saves more time than having folks coming around the courtroom with three-ring binders and stacks of paper everywhere. So even though there may be delays from time to time, which the court doesn't want to have too long of a delay, it still ultimately, as I said, does save time compared to the old way of doing things, so to speak. Okay, with that being said, is there anything further before we proceed, Mr. Abuhav, from your perspective?
I don't believe so.
Okay, Attorney Decker, anything else?
Nothing else, Your Honor.
Okay, ready to proceed, Mr. Abuhav?
In this case, there's not really a question whether the town is in violation on the facts that were alleged, right or not. The town admitted in their answer that the violation occurred.
And Mr. Abuhav, I'm going to stop you just for a second. You're free to present your case however you choose to present. Is it your intention that you would be, are you intending to testify now yourself, or are you?
Well, currently, no, I'm just opening.
Okay, so it's an opening statement?
Correct.
Okay, when you are prepared, I guess I'll do it now just so that the record's clear. I will swear you in as a witness now so that in case any factual statements are made, I can have that verification for the record. Okay, so have you raised your right hand, sir? Swear any testimony you give today will be the truth, the whole truth, and nothing but the truth on pain and penalties of perjury?
I do.
Okay, thank you. Please proceed with your opening.
The town, as I said, the town had already admitted fault in their response to the petition to the court that the facts that alleged that at the June 21st meeting, the June 18 meeting, the town, the audience at that meeting was unable to hear. In their response, the town admits that Lief Huge stated, "Good, you do not need to hear," in response to Mr. Abuhav's second comment that the public wasn't able to hear. The violation is pretty clear. There's not much to dance around or split hairs about it. Although the statements are pretty clear on what was said, that the public has no right to hear, the town is still trying to make this as a, oh, nothing really happened, it was just remind. It doesn't mean anything. Several attempts during that meeting were made to correct the issue and have the meeting audible to the public. I made several remarks throughout the meeting that the public wasn't able to hear. Note that that's the first time I said it's almost impossible to hear at the very beginning of the meeting. These statements are all on video, as we can see later. And contrary to what the town might try to suggest or has suggested, no corrective action was taken at any point, neither during the meeting or after the meeting, to make the situation better. This could have been a discussion on many broader violations that the town engages, or the board engages on a regular basis. But when it comes to such a statement as the public has no right to hear, or good, you don't need to hear at a meeting, that really strikes at to the core of what right to know is, which is to public meetings ought to be open and audible to the public, and anything that goes against that is just a clear out violation. And it serves no other purpose other to deny the public from hearing and engaging within the town business. I'd like to call Lief as a witness.
Your Honor, I believe this one appropriate to not.
Oh, if you want to start, go ahead.
The defense to
Go ahead.
also make an opening statement with the plaintiffs done with theirs.
Sure.
Thank you, Your Honor. The town, in its answer, has admitted that Mr. Abuhav stated he was having a hard time hearing at the June 18th select board meeting. The town doesn't dispute that Mr. Hogue said what he said, and good, you don't need to hear, and that is what we shown on the video. The town does dispute that that in particular constitutes a 91A violation. The town acknowledges and admits that the public has a right to hear. The select board took many corrective steps to ensure that the public does have a right to hear, and that's in the evidence that the plaintiff has put into evidence. Number one, that Mr. Hogue apologized at the subsequent select board meeting and clarified his statement. Number two, the select board did vote to move their meetings back to the town hall after they had previously moved them into the fire department where this, the June 18th select board meeting was being held, because the town hall had been under construction earlier that year. Number three, Mr. Darrow reported at a subsequent meeting about everything that occurred at the June 18th select board meeting. And number four, of course, the minutes of the June 18th meeting are available. The video of the June 18th meeting was videotaped, and so the words and statements of the select board are generally audible on that videotape, as the court will see. All the documents that the select board reviewed at the June 18th meeting have been available at all times under 91A, and they were made available to the plaintiff as part of a discovery request in this case. So the town, number one, disputes that there was a violation. Number two, the town has done everything in its power to provide the plaintiff with the information that he sought. And number three, Mr. Hogue would testify that, as explained in the town's answer, the fans were on in the fire department, and the fans were what created an additional difficulty in hearing the meeting. And the reason that the fans were on was that the town was in the middle of a heat wave, and so the select board was trying to expeditiously get through its business that evening, and that's what happened. I'd like to suggest to the court, for the benefits of streamlining this case and moving it forward, that the first piece of evidence that should be presented is the relevant video of the June 18th meeting. I think that's essential for setting the framework of all that follows, and I believe it would be a waste of everybody's time and resources if we were to proceed in any other fashion in terms of putting in any other evidence, because the only claim in this case is that
words, as the person bringing the suit, you have the right to, he's making a suggestion and a request to the court, but you're the one who has brought the suit, and it's your right to go, your right to go forward as you proceed.
Yeah, I'd like to start with going Lief to testify, and within that I will then introduce the witness.
Okay, during his testimony?
Correct.
Okay. So the request by Attorney Decker is noted, and I will allow the plaintiff to proceed in the fashion that he chooses to do so.
Okay.
Okay. And before you see the remain standing, just a second, please. Mr. Abuhav, as of right now, just so everyone in the courtroom is aware, the monitor that is in front of the witness stand, that particular computer monitor is controlled by the court monitor here. So is there anything, right now we're delete anything so there's no exhibits? Okay.
Yeah, he's good.
All set?
Yeah.
Okay, so, and if you're presenting through case lines, then the court monitor can track that. We'll see how things go, but the witness does have a different monitor up here that the witness can look at, depending upon whether you are presenting or whether we're asking the witness to follow along. And so, Mr. Ho, am I pronouncing that correctly? If I could raise your right hand. You swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth, and contains the penalty of perjury? Okay, thank you. Please be seated. And for all witnesses today, first thing I would ask is just that you please state your name for the record and spell your first and last names for the record. And Mr. Abuhav will proceed.
Right. Lief Huge, Leifhuge.
Thank you.
Question regarding the case lines. Do I need to direct a page each time, or is that the court? Are you?
So
can
it's up
just
to
see
you,
what-
if you want to present, or if you don't feel comfortable doing that, you can tell us, we all have access to it, and I can bring the exhibit up for the witness.
Okay.
Is that how you want to proceed?
I'll see how it works. I've
Okay.
never used this. What is your position within the town?
I'm the select board chair.
For how long have you been the selectman?
3 years.
During that time, have you taken training regarding valuable name?
Yes.
When was that?
I believe it was last time NHMA had their 91A seminar.
Was that last year during April?
I believe so.
And you attended the entire seminar?
Yes.
Do you remember how long it was?
Eight to 4.
So you were the chair on the June 18 meeting, is that correct?
Yes.
you were in charge, conducting the meeting.
Yes.
I'm trying to play the video, but I don't, is that gonna pull up automatically or what's the?
So what exhibit are you looking at?
That's, exhibit 9.
Okay, I'm going to go down here. Do you see what I'm seeing? Would you like me to hit play?
Can you see it on?
It's not connected to that. We all have they have their own view.
Okay.
Okay, and before we begin, you're about to, you'd like to witness the review plaintiff's exhibit 9, am I correct?
Correct.
Okay, Attorney Decker, any objection with respect to plaintiff's exhibit 9?
Plaintiff's exhibit 9 is a 53-minute video of the full select board meeting, and this is the video that I suggested that the court view. I've highlighted a few timestamps where I think about minute-long clips of the video would be relevant to Mr. Abuhav's claim. So perhaps Mr. Abuhav would like to specify the timestamps of the short relevant sections of the video.
Okay, but as far as empty, and understanding the issue relative to presentation of evidence and the manner by which it's presented, is there any objection relative to authenticity of foundation or relevance relative to the general admissibility?
No, Your Honor, I stipulated with the court monitor that all of the minutes and select board videos are admitted as full exhibits. We'll have objections to, on the grounds of relevance, perhaps. This entire 53-minute video is not relevant to the issue, but certainly short timestamps are.
Okay,
I do not intend to play any of the videos at full. There are hours in there. We're probably going to look at a total of around just 10 minutes or so of the video. They are just a few a minute here and there. So none of that should be an issue.
okay. My understanding is that exhibit 9 is a full exhibit.
It is a full exhibit.
Okay, thank you.
All exhibits are in full. I just uploaded them in case there's any question or if something was out of context or something.
Thank you.
So we're
Right, but 9 is.
9 is a full
Right.
exhibit.
Yeah, thank you so much.
Yeah, all of the videos are, the entirety of each video is admitted as a full exhibit. We haven't stipulated that every exhibit is admitted.
And just so we're clear, by use of the term full, we're not talking about full in terms of length and duration. We're talking about a full exhibit that the court can consider as a substantive exhibit as opposed to an exhibit which is being marked for identification purposes, which has not yet been entered as a full exhibit. I don't want any confusion relative to the use of the term full.
I'm not sure that I understand.
Sure. For every document, for every document that a witness is shown, it needs to be marked for identification, which is number 1. In other words, is the document what it purports to be? And so the opponent can object relative to authentication, foundation, or even relevancy, but assuming that the document is what it purports to be, that it has not been altered or doctored in any way, the court finds that it has established a sufficient authenticity, foundation, and or relevance. It then is no longer considered for identification. It is now considered a full exhibit. So by using the term full, I'm not referring to the length of the video clip. I'm referring to whether or not it's been admitted as a full exhibit, as in contrast to an exhibit for identification. So I didn't want to have there any lack of clarity relative to the terminology being used.
Okay. I've got it.
Okay.
All right. Can we
ideally you should be presenting.
Okay.
So you
And
would-
presenting means
I'm also happy to be the presenter
Okay.
and can play the clips that
Oh,
Mr.
that would be
Abuhav is
awesome.
requesting. If that's easier.
Are you, so he would do the
Can that
same,
be on the big screen?
it's not, that's not how it works.
Okay, there's more volume at least.
I turned it up.
So Attorney Decker, if you're willing to run that role as
So
a request?
you're going to present?
I'm happy to be the presenter, and play the clips that Mr. Abuhav calls for.
And let the record reflect that at this point, what we're looking at is plaintiff's exhibit 9, which is marked as a full exhibit, and per the plaintiff's request, the first minute was played. We're now attempting to use the baseline's motion.
Okay, so now I have the red box around my screen. Does that mean everybody can see?
Yes, I just clicked and it looks like it's working. I have the proof. Is it working for you?
Okay.
Okay.
So-
All right, so you have control, so,
Mr. Abuhav asked for more volume, so I don't know if I have control over that, but I understand that to mean he wants to replay the first minute.
Correct. Very difficult to hear, you know, noise or sound or something.
The planning board had a special meeting this past Friday for two reasons. One was to write a letter of support for refreshments in the grant that she's applying for. And based on the history of the last letter that the library submitted for a grant, Angus did the right thing to go.
That was 1 minute and 12 seconds. I fell asleep there.
You heard the statement at the very beginning that I said on here.
Yes.
Did you do anything at that time?
No.
Let's skip ahead to minutes 6 to 7. What? I'm just having, I love this computer, I'm having an issue to present myself.
Sure. And then did I hear you say, you want 6 minutes 6, is it correct?
Yep, 6 to 7.
6 minutes to 7. It looks like I'm starting the video at 5:59 is the closest I can get the dragon.
Thank you very
The
much.
scroll bar.
yet again, a few minutes in, I say it's impossible to hear. What do you say in response?
I don't know.
Did you not hear what on the video?
No.
Did you hear what I said at the time?
I did.
But yet again, you didn't do anything to correct the circumstance?
I did raise my voice.
You did? Okay. Whose responsibility is to have the meeting audible and the venue open to the public?
That would fall in the select board.
Okay. And you as chair, you're in charge of the conduct of the meeting?
Yes.
Okay. So would you be your responsibility to make sure that the public is able to hear at the meeting?
Yes.
But yet again, even though you were told and you heard that the public can't hear, you didn't do anything to change it.
I raised my voice.
Do you believe that was sufficient for the public to hear that part?
At the time.
Did you raise your voice after the first comment or the second comment?
Second.
Why not after the first comment?
I didn't realize it was that hard to hear.
So you're saying you raised your voice in an effort to correct the situation after the second time that you were told that it's hard to hear. Is that correct?
Yes.
Okay. Can you please pay 1120 to 1220?
Just waiting for the wheel to stop spinning.
While we're waiting, let the record reflect that the court is able to observe these on my screen, based on its functioning without difficulty.
Can you hold it for a second? If it's being presented, is there a reason I can't see it on my side?
Are you following?
Is there,
Yeah, so.
can you start again, please?
Sure. If you want to come look at my screen, if your screen's not loaded. Starting at 11:20.
Can
picture, get better audio?
Who moved the camera?
You did?
I've been video meetings before, at the selectmen meetings.
No?
Have I filmed selectmen meetings prior to this meeting?
Oh, sorry, I thought you asked if they get moved during the meetings. Yes, you have.
Okay. How many times did you say so?
Over how long?
Over a couple of years. More than you can easily count, correct?
Around 30-ish.
In any of those times, did I ever move the camera to the